Okay, well, good morning, everybody in the UK. Good afternoon, evening, everyone in China, and good day, everyone in between. Welcome to this webinar session this morning on online patent enforcement in China. With two great speakers, as usual, with Jamie Rowland from RAG, Lawrence Graham & Co., and we've got Tom Duke, who's an old friend of ours in IP-related things. They'll give us an insight on this extremely important topic, as e-commerce is so fundamental and important to retail in China. This is an extremely important part of it for our member companies and for indeed any company doing business online in China. So just before we begin, I'll give a little bit of a background of the China-Britain Business Council. The CBBC is the leading organization helping UK companies grow and develop their business with China. CBBC supports companies of all sizes and at every stage of market entry with practical in-market assistance, services, industry initiatives, as well as a membership program offering access, seminars, and significant networking. CBBC works closely with UKTI and the FCO and has a strategic partnership with the British Chamber of Commerce in Beijing and in Chongqing, Chengdu, and Guangzhou, providing corporate members with reciprocal membership. Our business-led board and professional team have extensive first-hand experience of doing business in China, and through over 60 years of engagement, CBBC has built up exceptional connections with government and business across China. CBBC services are delivered through a network of 10 offices in the UK and 13 strategic locations across China. CBBC helps companies to network and learn from China-savvy multinationals and SMEs, to understand the intricacies of doing business in China, and to develop sound strategies for expanding in the fast-changing and dynamic marketplace that is modern China. So that's just a little bit of background about ourselves. If I could ask you all just to click, you should have this little control panel that you're seeing there. If I could ask you just please to click on the raise your hand section there, that will just make sure that you can hear me basically, so I'll know that. So let me just see how we're doing, see if people are raising their hand. If I could have a, yeah, people are raising their hand. Fantastic, so well done class. I'm going to put all of your hands down again, thank you for that. If you have questions, this is a pretty interactive session, so no matter what question you have, please type it in to the area that I'm highlighting here. If it's pertinent to Jamie or Tom's words when they're presenting, I'll just cut across and ask them the question directly. If not, I'll save it till the end, and if we don't get to it during the live session, I'll be happy to pass it on to the speakers and they can follow up with it afterwards. So that's pretty much it from the housekeeping perspective. Just to give a little bit of background on our two speakers today. Tom Duke is part of the UK Intellectual Property Office's International IP Attaché Network, which includes attaché postings to India, Brazil, and Southeast Asia. IP attachés help to build relations with the governments of host countries to understand and actively engage with IP policymakers. The network has significantly increased the level of support available for UK businesses operating within these important markets. Tom works alongside UKTI, the British Diplomatic Network, and UK and EU level industry associations and projects to ensure that UK stakeholder IP concerns are addressed and smoothly integrated into bilateral policy discussions. Tom was director responsible for the IP Centre of the EU Chamber of Commerce in Seoul in South Korea. In Korea, Tom designed and implemented government engagement programs on IP on behalf of European companies and launched projects to enhance regional cooperation on IP enforcement. Tom has lived and worked in the region for 10 years and speaks fluent Mandarin, Chinese, and Korean. So as I said, Tom is an old friend of ours here at CBBC and definitely somebody you need to know for any area of IP in China. Few people have his knowledge and network and connections. All right, and just our second speaker today, Jamie Rowland, is a partner in RAG, Lawrence Graham & Co.'s IP team. Jamie qualified in England in 2001 and has considerable experience in all areas of contentious IP matters, and has acted for UK and international clients on patent, trademark, design, and anti-counterfeiting disputes in the English Intellectual Property and Enterprise Court, High Court, Court of Appeal, Supreme Court, and the European Patent Office. He often advises clients involved in multi-jurisdictional disputes. He has a particular niche practice for technically complex and high-value international arbitrations. That's quite a mouthful. Technically complex, and say that 3 times quickly. Both institutional and ad hoc. Within China, Jamie has had considerable experience in helping clients protect their intellectual property rights, including on e-platforms, and understands the commercial considerations and potential avenues any potential litigants should assess before and during the process. Jamie also has experience in all aspects of intellectual property transaction. So that's just a little bit of background. Jamie, I'm lucky to have Jamie sitting beside me today, which means there's one less internet connection to worry about this morning. All right, great. So as I said, this is an interactive session. So just before we begin, I'd like to launch a poll, and that poll is, where are you? So if you could please just click, you should see now, if you could click and then hit confirm, and that just gives us a sense of where everybody is this morning, and I'll share those results with you. Just give it another second or two. All right, that's very good. Almost everybody has voted. So as we can see from these figures, I'll just close that and share with everybody, 50% of our listeners are in the UK outside London. I think one of the reasons that we have this platform, and this is nearly our 50th webinar, I think we're maybe at 48 or something like that, is to give access to this type of content to people who wouldn't be able to travel to events or mightn't have the time. So hopefully in this quick hour, you'll be able to get up to speed on what you need to know to support your business in China. All right, brilliant. Well, let's move along. I am going to now hand over, if I could, let me unmute you. I'm going to hand over to Tom in Beijing. And Tom, please do speak up. Tom, we're having connectivity issues. Let's hope it settles down. Do you want to start again? All right. Tom, your connection is pretty poor. So what I'm going to do is I'm just going to go straight. I'm going to go straight over to Jamie, and we'll see if we can't get you back on. So Jamie, a little bit ahead of schedule, but let's hand over straight to you.
Okay, well, thank you very much, David. And well, I was going to say thank you, Tom, but I haven't heard anything from Tom yet. But let's hope he sounds less like he was in a goldfish bowl later on this morning or this afternoon if you are in China. It's great to be here. I obviously overdid my introduction that Mark was tripping over. David was tripping over earlier. But yes, I'm based out in China, although currently in the UK. And as a firm, we deal with an ever-increasing amount of e-marketplace enforcement issues, both in relation to patents, but also trademarks and copyright as well. Of course, today we're going to focus on patents. Well, what I'm going to do is speak for about 25 minutes, possibly 30 minutes, but something in that order. Very happy to take questions as we go along. And what I'm going to try to distill in that time is sort of some practical pieces of knowledge that we've picked up, having dealt with various different types of clients and indeed e-platforms within the China space. So, I mean, as we all know, it's quite apparent that e-marketplace globally are increasing, but that is never more so than in China as well. I mean, I always like to throw out a few stats, as speakers often do. But in 2013, the Alibaba group were trading to the extent that they were having to pay 20 million RMB per day in tax. That's about £2 million every day in tax for the trading that they were doing. There was a survey done by the E-commerce Research Centre about units of goods traded within China on e-commerce platforms. And the statistics are pretty staggering. In 2012, they estimated 7.85 trillion units. It was up to 10.5 trillion in 2013 and estimated for 2014 to be 13.4 trillion. So it's a staggering amount of trade that's going on. And of course, with that amount of trade, it is unsurprising that there is a level of IP infringements, including patents, that occur on these sites. And unfortunately, still at this stage, although I think the situation could be said to be improving, it is still pretty prevalent. The good news is, and I think it's good to sort of front this up straight away, is that yes, there are a lot of infringements on these sites, and that's not going to disappear anytime soon. But there does seem to be a move from Chinese e-marketplaces to try and tackle, at least to the degree necessary, and I'll come on to this a bit later, to try to tackle the problems with IPR, including patent infringement on the site. And I'm going to have a look at some of those issues a bit later on. When we talk about online infringements and a general strategy to adopt, I think it's really important that if you are an entity that is interested, I think actually in online enforcement in any jurisdiction, but particularly so in China, you shouldn't just look at that strategy in isolation. Because the information you can get from monitoring e-platforms actually can be incredibly helpful to a wider enforcement strategy and understanding and learning about the specific Chinese marketplace. Who's doing what? Who's manufacturing? Who do you really need to target, and what are they doing? So I think it is important when looking at this sort of issue, just to remember it's a broader brush strategy to consider. Just very quickly, just because this talk obviously is focusing in on patents, let's just be very clear what we mean by patent in China. In the UK, when we speak about patents, what we mean is invention patents. Not so in China. There are 3 different types of patent that you can file and obtain in China. The first is an invention patent, and that can be a product all process. It's once filed, you get 20 years protection, and the test is that it has to be new and inventive, effectively. What you also have in China, though, is a utility patent. Now, these are a bit more quick and dirty. They're not dissimilar, actually, to invention patents. Excuse me. Although the focus is on a product rather than a process. The benefit of utility models are that you can obtain these far, far quicker than invention patents. And not for the subject of this talk at all, but it's worth noting that if you are interested in a filing strategy within China, one can file utility and invention patents at the same time to get quick protection under the utility patent, whereas the invention patent takes 3 to 5 years to get registered. So utility patents, 10 years protection, and the critical feature is that it's the product rather than a product or process. And the other area that we'll be discussing today is in relation to design patents. And that is, I suppose, really the equivalent to our registered design in the UK, for those that are familiar with that. And it's dealing with the shape and configuration of a product, and you get 10 years protection. So that's what we're going to be discussing. Now, I think it's, again, worth just mentioning that all these rights, whether it's an invention patent, a utility patent, a design patent, can be protected on e-commerce marketplace platforms. There is a misconception sometimes that really it's only about trademarks, it's only about copyright. That's not so. All these rights can be protected. I think it is important to understand that there are challenges with these types of rights. And I would say in the order of preference, i.e. the right that is probably most easy to enforce, going to the more difficult, would start with the design patent, followed by the utility patent, and ending in the most difficult to enforce would be the invention patent. Why? Well, because effectively invention patents can get complex. You may be looking at parts of a product that you cannot see to the naked eye just on e-platforms. There may be a process patent, which again, from just obtaining evidence from an e-platform is going to be difficult, and then persuading the owners of that site that it is in fact infringing and should be taken down is also challenging. So I think the summary point here, and I'm going to go into this in a little bit more detail, is there is no restriction on enforcing patents in China for e-platforms, but there are challenges.
Okay, just as we're moving along, just help Jamie get a bit of an understanding of who's joined us today. We're just going to launch another poll, and it's just a question of have you registered IP rights in China? Just again, so we can get a sense and shape of the people who are joining us here today. If you do have any questions, and we've had a couple already, just do type them in to that little box at the bottom, no matter what they are. So we'll just give it another couple of seconds and let Jamie have a sup of water and gather his thoughts. Yeah.
Okay, so I'm just looking at the poll with interest. Seems to be changing around a bit. I'll just carry on in the meantime.
Yeah.
So we're going to switch slide, if that's okay, and then just have a bit of a practical look about.
We have our results here. I'll share them with you. So 38% no. I have not registered. Lovely typo. First up. 13% no. I have registered. I have
registered rights in the UK.
Yes, registered rights in the UK. 38% yes. I have registered rights in China. I think that's not enforced yet. And 13% yes. I have registered rights and also have been successful in enforcing them. So just there's quite a mix this morning.
Quite a mix. Well, some may find this talk at a too basic a level. I hope it's pitched generally at the right level. It looks a little bit like the audience is 50-50 really. So let's see how we go. So this is just really a practical point now about, it's all very well saying yes, you can enforce patents online. But really, the question is, how does one go about that? What is a strategy that we see day to day when we discuss these types of issues with clients? Because of course, if you break it down to trademarks, for example, there is a slightly simplistic method. It doesn't always produce results, but effectively, particularly if you're dealing with a word mark that you are concerned about, of course, by putting that term, or maybe using some Boolean searches or some sort of variations around the mark that you are interested in to try to capture as wide a search result as possible, that will then draw up your list of potentially infringing marks, and it is a case of going through them, and you will have to take a view as to whether you feel there's infringement or not, and can decide on a strategy based on that basis. Of course, it's slightly more complex with patents, because what you're really looking at, whether it's invention, utility, or design, is a product that is infringing, and of course, within each e-platform, you are going to have to devise a strategy in order to come up with products of a similar type for you then to go through the process of looking at the listings and deciding whether in fact you want to do anything about those. So I think I've put up a few bullet points on this. I mean, the most important point is to try to understand your market, whether it's in China or outside. And that just takes time. It takes research about who are potentially infringing parties, where are they based, what are they doing, what brands are they punting out, because those can be used in your strategy decisions. But basically, because of the way platforms work, the process actually is not dissimilar to that with trademarks. You're still going to have to use the site's search functions to try to draw up. You're going to have to put in product names, the type of product, be as specific as possible, but not too specific in order to miss out on potentially infringing goods. Use brand names, company names that you believe may infringe. And that will result in a list of potentially potential infringers. And then, of course, what one has to do is go through that list to assess whether, in fact, there is an infringement of any one of your registered rights within China. Okay, next slide.
Sure.
Bit of background law. It's probably far too early to start getting into the nitty-gritty of law.
It's never too early for law.
Right now. I'm going to make this quick and snappy. But I mean,
you're the first lawyer to ever say that.
But I mean. Why they are trying to up their performance of takedowns really comes back to this principle of a safe harbor principle, which is born out of various legislative rules, both in Europe and the US. In Europe, the key case was L'Oreal versus eBay, where this issue was discussed. But effectively, an e-platform has to be very careful in what it does to allow itself to be seen by law as merely a host of information, rather as something more active than that, as some form of facilitator to the sellers on the platform. If you are just hosting content, then you're allowed what's known as a safe harbor. To incur this safe harbor principle, which means it's very difficult for you as the platform to be held jointly responsible for any infringements. And this position was adopted in China back in 2011 through the Elan versus Taobao case. And what that has meant is that China has had to follow suit with the US and Europe, and really does need to stay on the right side of the safe harbor principle. And the way to do that is that if you are notified of a potential infringement and that provider actively believes that there is infringement, it has an obligation to take down. And if it doesn't, then the safe harbor principle is removed, and you can be held as the platform provider can be held jointly liable with the infringing seller. So that is why the move has been made, and it does mean that Chinese e-commerce providers do have to take this legal risk seriously, and it's why we have seen better performance from e-platform providers in taking links of infringing goods down. So on to the next slide. This is really just a slide to look at who the major players are in China. There are a couple of international players on here, eBay and Yahoo. I think, as everyone I'm sure knows, the biggest e-platform provider by some distance in China is Alibaba, and they have a number of subsidiary sites, and they are listed up here. There's Alibaba.com, there's Taobao.com, there is AliExpress. There's also Tmall.com and Alibaba China. They are all part of the Alibaba group. But then you have other Chinese online marketplaces, such as Made in China, DHgate.com, Global Market, and Global Sources. The majority of these are business to business, but some, such as Taobao, AliExpress, are consumer to consumer, so the equivalent of eBay. And when you're developing a strategy for online marketplaces, the critical thing to look at, whether it's for patents or trademarks, is to make sure that you are visiting the sites with the most traffic. It may be that the links on certain sites are lower than others, but if there is a site with multiple links but very, very little traffic, the reality is you want to move your attention, or most likely want to move your attention to another site.
Okay, I've got a question here from Susan, and Susan's asking, we are aware of infringing products being sold through the Alibaba.com site, B2B. Can we get information from Alibaba about the seller so we can bring in an offline enforcement case, e.g. through the Chinese courts?
Yeah, good question. Well, I mean, Alibaba are actually are usually pretty good. There isn't an obligation to provide information. Their obligation actually rests in the fact that that they need to go through the takedown procedure, and if they believe there is an infringement, they need to take it down. However, there is information that you should be able to glean as because it is a B2B site, and therefore they should provide Alibaba, for example, their business registration information. And I think it's what is very important in these types of cases is to try to develop a relationship with the e-platforms themselves. And I know Alibaba actually, and I believe Tom may be speaking to this shortly, really is trying to open its doors to IPR holders, and where it can, subject to data protection, etc. Issues, it will provide information to help with the civil action.
Yeah, I just add to that in case we get Tom, in case we can't unravel Tom from cyber mess. The CBBC actually signed an MOU on IP with the Alibaba Group in September 2014. Hopefully we'll get Tom to talk a little bit more about that. But ultimately the goal of that is to help British companies obtain better IP outcomes using the system, and work with Alibaba as well to improve their systems in the medium and long term. They do have a round table which is held every few months with Alibaba's internet security team, and the next one of those is in early August. So please do contact either myself or anybody connected with CBBC just to know a little bit more about that, just to give some background on that. Anyway, we'll move along. Next slide.
Next slide, please. Yeah.
Smashing.
Okay, so again, just another piece of sort of practical information here really is just what you actually need to submit to get a patent infringement complaint off the ground for on an e-platform. The most critical thing here, of course, is you need to actually register your IP in China. This is hotly debated, and I know certainly for SMEs, there's always a debate. It's a financial debate, it's a budget debate as to whether, which jurisdictions can you register rights in. If there is any inkling that China could be a jurisdiction of interest, our recommendation is always register some IP in China. I mean, the reality is if you want to enforce online in China, you do need registered IP.
Yeah, at CBBC, we would absolutely stress that. I mean, even if, we found so many cases, and in fact only this week in the office, where a UK company called up and said, I was thinking of going to China, and I found all my IP has already been registered, my trademarks, my name, all of that kind of thing. And this company was baffled because China still has this first to file process.
Correct.
So it's all legal, I guess, in that sense. So, we would, as an organization, reiterate it, even if China's kind of on your radar, and you haven't got there, it's not good enough just to turn up and look, but even ahead of time, that would be one of the first pieces of due diligence that you do, I think.
I think that has to be right. Absolutely. So just whistling through this slide, the thing I wanted to highlight really was, because you need to set up with these e-platforms, You need to show proof of ownership. You need to show proof of identity. Patent specific, do just remember that if you want to enforce either a utility model or a design right, you're going to have to come up with what's known as an evaluation report. That's a report from SIPO, the State Intellectual Property Office, and it goes to whether in fact those rights are deemed to be valid at that time. That takes some time, so you do need to plan ahead for that. In relation to infringement, what you have to do from a practical perspective is list out all the links that you say infringe and then explain in a lot of detail why you believe they infringe. Again, specific to patents, what you're going to need to do, and this is where it will be good to get some legal advice, is forms of claim charts, breaking down your claims of the patents and explaining exactly why you believe there is an infringement. That can take some time, but it's absolutely fundamental that that part is right to successfully get the links taken down. Next slide. Here is just an example of a dispute resolution process for the Alibaba group. I mean, it's worth noting that actually every slide has a slightly different way of doing things, and some of the non-Alibaba companies don't actually have such a specific procedure. It's done by email, but in principle, the documents you need are broadly the same, and the process, to all intents and purposes, are pretty similar. The diagram really speaks for itself. I think the points to note are that the process has a number of stages. IPR rights holder puts forward its case effectively. That is put to the e-platform seller, and they have an opportunity to come up with what's known as a counter notice. It is very interesting and perhaps unsurprising that when we're dealing with patents, the number of counter notices being thrown back at IPR rights holders are much more significant than in the copyright or trademark field. So be prepared if we're dealing with patents to see some form of notice, counter notice. If a counter notice is submitted, then the IPR rights holder has another opportunity to put forward its case or explain why it believes that the seller is wrong. And at that point, the e-platform effectively becomes judge and jury, will look at the complaint and make a decision on that basis. You're never going to get to see the decision. It's not a court of law. It's going to be, sometimes there is email notification that the link may be taken down or is staying up, but you don't get detail on it. And here lies the rub. The reality is when patents get very complex, it does get more difficult to persuade the e-platform to take it down. Why? Just because frankly, it's just in the too difficult pile. And as long as the platform provider looks like it has done its best in order to comply with its safe harbor obligations, it will likely keep the link up. What do you do in those situations? There's no appeal process. What you have to do, if it's strategically important enough, is actually then take this matter out of the e-platform complaint procedure and consider starting a civil complaint. You can either do civil litigation or go through the administrative route in China, both of which will get you as a result at the end of the day.
I've got a question here from Marcel. Marcel asks, or says, and then asks, it seems that oftentimes patents trademark infringers hide their actions by using the translated version of the brand. For example, using Chow Dan for Jordan. You may know that hilarious logo where the slam dunk is slightly lower than it should be. So how to police the use of language to get to an infringer's activity? So how to get around this idea of language with the infringers? Any thoughts on that?
I mean, it's a difficult one, isn't it? And in many ways, it's like all these things. It's how much budget have you got? How hard are you prepared to work on the e-platform? How big is your team of people, frankly, monitoring? Because it is a little bit like how long is a piece of string. If you have the resource, then of course someone can be dealing with the translation issues, and they just have to look out for them. But unfortunately, it really is just a case of resource and monitoring and planning accordingly. There is no simple answer to that, I'm afraid.
Okay. Fair enough. Okay.
Right, I'm conscious of time.
Yeah, we've probably, I think we're doing okay, but let's keep moving.
So, counter notices. I mentioned counter notices in the previous slide. The point I wanted to really highlight here is counter notices can be used strategically well in your bigger picture of enforcement strategy. And the reason for this is that in a counter notice, what the seller will have to do is explain why it believes it doesn't infringe, and it does this usually in a number of ways. And I put a number of them of my second bullet point. So it may say that the products in question were actually in existence or being sold before the date of the patent in issue. But one that often crops up in China is that it has filed patent rights around the product, and they may very well be what's known as copycat patent rights, and could in fact be very, very close to rights that belong rightfully to the IPR holder. And this is a very good way of finding that sort of information out, and it may well be that will mean a choice of trying to invalidate that patent. So my point is that these counter notices can be used to add intelligence and know-how about what's going on in the marketplace, and may actually dictate how strategy goes forward. Okay, next one.
Okay.
Very quickly on this slide, this is really just a point to note. Whereas Alibaba and the subsidiary companies has a very set out procedure for dealing with online complaints, many of the other local Chinese websites do not. And the way to deal with those is usually either by email, telephone, and that will allow you to send in the required documents to prove or attempt to improve infringement and try to get the listing taken down. Again, I just want to stress that it's really important to try and get a relationship with these types of companies if at all possible, because that will really help in the takedown process. Okay, next slide.
Okay.
The relationships with offline actions is important. You can learn so much from online monitoring. For example, you can find out about new entrants into the market. It is very, very usual for companies who are thinking of dipping into infringing activities will start off online, and so by monitoring, you may actually find out who these new entrants are much more quickly than if you didn't monitor it. Checking infringing status is another one. There may be settlement agreements you've had with parties. A very good way of checking that these infringing parties keep to the bargaining of their undertakings, i.e. we've agreed not to carry on infringing activities, is actually by looking online to see what they're doing online. Locating potential copycat rights we've dealt with, so I'm going to skip over that. Mm-hmm. Next slide really is a bit of a recap slide, so again we don't need to spend much time on it, but I do like, it does set out nicely the fact that 2013 there were over 100 million takedowns enforced. 30% of those relates to patents. Now, if you split that out, by far the highest will be design patents. It will then be utility, and languishing somewhere in the background, unfortunately, would be invention patents. But it's still a decent percentage of the overall sum.
Is this a China number or a global number?
That's a China number.
Oh, wow, okay.
Better than that, I believe it's an Alibaba number.
Okay.
Next slide, please. This is interesting, I think. Again, misconception. There is a belief that most listings just immediately go back up. So what's the point of doing this anyway? Actually, WIPO produced a report that found that 25% of companies that were selling infringing products stopped completely if, in fact, they were asked to take down their infringing goods. Now, that in itself is quite an interesting statistic. Why? Well, if you're actually thinking about larger scale enforcement outside the online platforms, civil litigation, administrative actions, they are expensive. The beauty of online takedowns is they're cheap, quick and dirty. If in fact you have a strategy that can immediately get rid of 25% of infringers before you have to go onto the real, I say real, that's a little bit unfair, but onto civil litigation, big ticket litigation, actually it's a rather neat way of dealing with a cut of infringers. So again, it's a recommendation of why it's a positive thing to do some online monitoring. And also, again, in the spirit of these e-platforms trying to really improve performance, there are methods that the Alibaba group of companies are trying to put in place. I mean, they have put them in place, sorry, but trying to help sort of better enforcement. Because they deal head on with repeat infringers. The reality is that there is quite a long way to go on this.
I've got a question here from Rowland, and it's perhaps a little contentious, so answer as you see fit. But is local Chinese government interested in persistent infringers? We have had thousands of listings taken down by Alibaba, and there seems to be no penalty.
Yes, well, I mean, that's interesting. In relation to what I've just said, of course, Rowland. So. I mean, are they interested? I mean, I suspect it's 6 of one, half a dozen of the other, to be honest. I think everyone's doing what they need to do, but probably not going much further than that. I mean, I think the difficulty we have, I don't think it's a China-specific thing necessarily. I spent a good chunk of time working for a film studio and spent a lot of time dealing with their Vero program for eBay for their a lot of marketing material. You know, eBay had the same problem. The Vero program was always seen as a very good thing, but the reality is people used to give false information when stuff was taken down. The very next day they'd put it up again using a different identification. There are these platforms are huge, and the enforceability issues are definitely not ideal yet, and I can understand the frustration. What I would say is I think that they are moving in the right direction.
Okay, nice diplomatic answer there, yeah.
I'm going to close by just giving you, some key tips for a successful monitoring program. And the key points really are build relationships, and be patient. It's a frustrating job, but it does reap rewards if you stick with it. Ensure, and this really goes with building relationships, try to not overreach when you're trying to do your takedown policy. If you become seen as a company that's literally trying to wipe out everything that exists on e-platforms, whether or not it infringes, that's not going to be good for the building relationship aspect. But the critical point is be persistent. you just got to keep chipping away. You will find some interesting intelligence along the way, and you will get results. And from our experience, and I will show you a slide in 1 second without going through them all.
Sorry, just you'll find some interesting intelligence along the way. What do you mean by that?
So it goes back to really what I was saying before. So because infringers tend to use online marketplaces as their first step into the world of infringers, they might come across a product that looks interesting. Before they invest money in buying mold, setting up a shop or anything else, they will dip their toe in and use an online marketplace.
Right.
Now, if you are monitoring the online marketplace and you catch that quickly,
right,
frankly, you may be able to do something about it.
Yeah, nip it in the bud, I guess.
Nip it in the bud.
Yeah. All right.
So be persistent. Finally, I'm not going to go through all these slides. You can, I believe you're going to get this slide deck at the end of today.
That's
right. If you go to the next slide, I just want to. So this is in relation to a monitoring campaign we did on behalf of a client over a 2-year period. And what's interesting is, so 21,000 links were taken down. This is all related to patents, by the way, design, utility, invention. 21,197 links were taken down. The success rate was 91.7%. And that is a very, very good success rate, which just mirrors the fact that if you are persistent, then you do reap the benefits.
And this is a China Alibaba figure?
This is China.
Okay.
It's not. It's all the sites that is on the previous slide. So it's Alibaba,
right.
Taobao, obviously part of Alibaba, made in China, DHgate.
Okay.
And I'm going to leave it there because
I mean that's very much against sort of the perception of it. I mean, to have that sort of success rate. Do you think that? I mean, because we do get is it that buses are always late in the sense that you only remember when a bus is late and you don't, when you get on the bus and go somewhere, then that's fine. Is that what makes it such a big public issue, or is there still a real problem with this? Because
there's still
the
a real problem.
perception is that there's a real problem.
No, there's a real problem. I mean, I think the point here is when you find infringing links, more often than not, even on patents, they will be taken down. The problem is repeat infringers, i.e. they go back up again.
Yeah.
B, are we really only just touching the sides? To try to take everything down, even if you have an army of people, is actually very, very difficult. It's just the size and quantity we're having to deal with. So whilst you have your successes, that doesn't necessarily mean it's going to put an end to the infringing activities.
Okay. And you have a conclusion slide here. Perhaps you want to go through some of the points on this. I'd also encourage people to tap in a few questions. I have a couple of waiting in the wings, but if you have any specific questions, please type them in. And in a couple of minutes, I'm going to put a PDF into the system, and you'll be able to download the slides and specifically some of those charts and some of those figures that you saw. So perhaps you want to,
Yeah, sure. Well, I mean, really, in conclusion, and I'm trying. It is a positive conclusion, but I think it's important what David and I have just been speaking about. There are positives, but it is an enormous area, and keeping constant monitoring is a very time-consuming process. Now, companies with limited funds are going to find it more difficult, particularly doing it from the UK, frankly. So it is not without its challenges, and I definitely don't want to give the impression that I am literally painting this sort of rosy picture that all is well with the world. What I'm really saying is that there are provisions that have been put in place to make the process better, and we shouldn't lose sight of that. In conclusion, the online monitoring strategy that should be adopted should be just one prong of a strategy that is adopted in China generally. It does produce good intelligence, the monitoring. It can be helpful for other pieces of litigation. and just really for understanding what is going on in the market in China. And if you have IPR, that is a valuable set of information to have at your fingertips. Again, on a positive is that the legislation does seem to be focusing in on the problems of e-platforms and trying to get some form of solution to it. Again, it's likely to take time to actually see a practical effect. But recently, SIPO, so the State Intellectual Property Office, made into law the measures for patent administrative law enforcement. It came into force only a few days ago. And it had a real focus on e-commerce. It also actually had a focus on exhibitions such as the Canton Fair. But it's really strengthened what the administrative authorities can do in the instance that they find that a particular product is infringing, and they know that it is being sold on e-commerce websites. So they can now go straight direct to these e-commerce platforms and make sure that they are removed and do have some power over the e-commerce platforms to ensure that this is done. Again, a good development. We'll have to see how, in practical terms, it really affects things.
Okay, lovely. We have a few questions. I am just going to see if we've got quite a few questions ringing in. I'll just see if Tom is out there. Tom, I'm going to unmute you again. Are you there, Tom?
Hello, David. Yes, we've had a quick change of headset here. Is that any
Hurrah! We have Tom. Tom, I'm going to shoot back to your slides, and we're going to do it all in reverse. Why don't you give a little bit of an introduction of your topics?
Yeah, thank you, David. A belated hello, everybody. I was down to do a bit of an introduction ahead of Jamie's talk, but that seems a little bit superfluous now. So what I'll do instead is maybe build a little bit on some of the things that Jamie has said and talk through some of the case studies of types of company cases that have been supported underneath the China-Britain Business Council and Alibaba MOU. So, David, if you can go to the second of the two slides. David did mention this during the talk. In September 2014, the CBBC signed a Memorandum of Understanding with the Alibaba Group, focusing particularly on intellectual property. It's something that I personally and the British government through the embassy has supported throughout its implementation, including at the beginning, which happened during the visit of our Minister for IP, Baroness Neville-Rolfe, last September. So the MOU is looking to both help companies deal with issues they have now, but also to help Alibaba develop more effective schemes and effective initiatives to protect IP over the medium to long term. The main way we have supported this work over the past several months is to organize a roundtable meeting at Alibaba headquarters with senior people in their internet security team covering the whole group, so all of the Alibaba e-platforms, and to have an in-depth dialogue both regarding particular issues that are present at that moment for British companies, but also looking at some of the longer-term reforms that the Alibaba Group is bringing to their IP protection service across their websites. So to give some examples of some of the companies that have been helped through this scheme, typically an inquiry will come in either to myself at the embassy or to the CBBC from a company in the UK, maybe saying in the first instance that they have located some infringing products that are being distributed through Alibaba websites. Perhaps it's through the Taobao consumer-facing website within China, or perhaps it's through the Alibaba site or the 1688.com site or other business-to-business platforms operated by Alibaba. In the first instance, we always give people an explanation of how to use the AliProtect system or the Alibaba system as it currently exists, to try to use that system to deal with the problem. It can take a bit of time to register with the system, but in the case where we're wanting to remove a smallish number of links, that is one of the most efficient ways to do it. If for whatever reason that is not resolving the problem, then we can escalate that through the CBBC MOU to the Alibaba central contact point. And Mick Ryan is the central contact point in the CBBC office, and he can raise some questions directly with the Alibaba side to try and work out why the online system is not able to solve the problem. If a back and forth through email or by telephone there is still not enough to solve the problem, then we can discuss it directly during one of the roundtable meetings with Alibaba that happens every 2 to 3 months. As David said, the next roundtable is in early August. That will focus particularly on patent and design infringements on the Alibaba platform. So if people are interested in that, please do get in touch with Mick Ryan, details on the screen there, and he can share some details about how that particular initiative will unfold. Particularly related to patent and design infringement, though, it's a problem that Jamie hinted at in his talk too, which is that a common response is that, well, determining patent infringement is a very complicated thing to do. It's something which judges and very experienced lawyers need a great deal of time to consider and determine in court cases. So how can we do this through a few emails going back and forth between an internet platform and the rights owners? Well, we've been down this road a few times in China, and there are a few thoughts that we have on how to overcome this problem. So first of all, not all types of patent, particularly if we're looking at design rights, which are a type of patent in China, are that complicated. Sometimes it is possible to demonstrate to a sufficient degree to the Alibaba counterparts that there has been an infringement, at least to demonstrate to the level that they're prepared to take the link down and then, if necessary, engage in a dialogue with the seller. Secondly, if they're still not convinced, though, by the fact that the patent or the design may be fairly simple, then Alibaba are always interested in seeing if you have any previous case decisions to present to them. So, for example, if a court or a local government intellectual property office has made a determination of infringement in a previous case on the same patent, then that can help to persuade Alibaba to take the case down. And then finally, and this is something we're looking at for the future, Alibaba announced recently that they have a new agreement with the local government intellectual property office in their particular part of the country, in Hangzhou, Zhejiang province in eastern China. And this agreement is to help Alibaba use the expertise within the local government office to have a better insight into whether there are patent infringements going on in some of the disputes that they're handling through the process. And again, we're looking to work out in a bit more detail how this will work in practice and how British companies can benefit from this arrangement next time we're down in Hangzhou in early August. So there are a number of different channels and ways to escalate disputes that are seen through particularly the Alibaba platform using the CBBC Alibaba MOU mechanism. So I encourage people to get engaged with that and to really work out how you can use this communication channel to solve the problems that you are currently experiencing through infringing products being distributed through the Alibaba platform.
Excellent. We have a few questions, and I do want to have a few. Everyone pretty much is still online. Tom, just while I'm shifting the slides, would it be fair to say then that you think Alibaba are making a real and significant effort in this area, or is it a bit of PR or a bit of a mixture of both? I mean, you know, they want to get the image out there that they're enforcing this. Is this a real thing that companies can depend on in the future, in your opinion?
It's a very good point, David. The first thing to say here is that the reason there is such a focus on Alibaba is because they are the big player in this market. The Chinese e-commerce market is booming. It is growing incredibly quickly and accounts for I think a disproportionately large portion of Chinese consumption, certainly when you compare it to the rates that you see in other markets. And Alibaba is the dominant player. It accounts for 80+% of the sales that are made on e-commerce platforms in China each year. So Alibaba is very important. As Jamie and I have referred continuously to Alibaba, perhaps more than other sites out there like JD.com or madeinchina.com and other sites, because they are such an important player. They deal with a huge volume of sales. A large portion of that is legitimate sales, and because they account for such a huge portion of the overall market, there is a significant volume of infringing products going through their sites as well. Over the now looking at around 9 months since the MOU was signed, and we've had this much closer dialogue with Alibaba, we have seen a willingness to engage, and we have seen a series of initiatives that they have presented to British businesses, which are potentially something which can have an impact in improving the environment over the coming months. I think that is signs of progress and signs of positivity, but as Jamie said as well, the real key to evaluating how successful these initiatives are will be when British companies, such as the people on the line today listening to this webinar, is when these kind of companies come back to us and say, yes, we have really seen an improvement based upon an Alibaba commitment that they made to improve their service.
Okay.
So I'd say it's a positive direction. Still,
okay, to that effect. I mean, I do have one comment here, which is positive, that says we have found Alibaba to be proactive and speedy in delisting. But while we're on this topic, just one final question from Marcel, and it's how much influence does Alibaba have in getting other e-marketers to police infringement?
So I would say that Alibaba, in terms of direct influence upon the platform, the influence will be fairly low. There are, however, a number of platforms who present themselves as being significantly cleaner than Alibaba, and they see that as something of a selling point. So even though they might not have their own notice and takedown mechanisms in place already, they say, you know, we are better than Alibaba, we're more responsive, just send us an email, give us a call, and we'll sort it out. I think the response to that is that, while in absolute terms, the volume of infringements on their sites may well be lower than the volume of infringements on the Alibaba platforms, but their market share is significantly smaller as well. So a number of sites are trying to position themselves as the clean alternative to the Alibaba platforms, but there's no real evidence out there at the moment to suggest that that is necessarily true. The key player here, of course, though, will be the regulators and the Chinese government, and if they show clear appetite and clear leadership in cleaning up e-commerce platforms and solving the problem, then both Alibaba and the other sites will need to comply. And there are, again, signs there that the Chinese government, the central government, and local governments are really taking this matter very, very seriously now. You may remember at the start of this year there was quite a lot of press reports about disputes between central government agencies and Alibaba about infringing products and other illegitimate trade on e-commerce platforms. And the Chinese government is working on a new e-commerce law which should be published for comment before the end of this year. And that again is seen as signs that the central government is committed to improving this environment and to making e-commerce platforms more trustworthy for Chinese consumers. And I think that's really key here, rather than the direct influence.
Yeah. Thanks, Tom. I hope that does answer. I've had quite a few questions coming in, around this topic along the lines of, what is the government actually doing? Are they taking this seriously? So I think I'm hearing from both yourself and Jamie that things are actually being done. I want to bring Jamie back in if I could. I've got a question from Philippa. Everybody's still online, so we can keep going for a minute or two. Just before I do that, I have put the handout into your little control panel, so you should be able to see a PDF of the presentation that you can all download now, which is a new feature on this little piece of software, which saves me having to do it afterwards. So I'm a whole lot happier about that. So just a question from Philippa. When would be the best time to register in China? Before you make your product design public in the UK or start selling online? Or do infringers look through IPO databases for ideas? I mean, this goes to the very heart of it. We touched on it a little earlier. Jamie, perhaps you can, as the expert here, yeah.
Well, I think, in an ideal world, you register before you allow anything to go public anywhere in the world. Is the best solution, because there are difficulties with prior publications. Now, there are grace periods depending on which right, and it's a huge topic. But in reality, if you want to be 100% safe, if you have a design that you are going to go public with anywhere in the world, it is best to get your design strategy, and I mean global strategy, set up and dealt with in one foul swoop to avoid any risks of invalidity issues going forward.
Yeah, as the old toothpaste advert was, it prevention is better than cure.
Very true.
Way back in the days, circa 1984, I think. We'll take a couple more. And this is from Michael. If one gets a ruling in one's favour, how difficult is it to enforce?
Right. Presumably this is a China-specific question. Enforcement in China is a problem, I think it's fair to say. Our experience of working with clients is that, and I'm now leaving e-platforms, and I'm talking about general civil litigation here. Generally speaking, in intellectual property disputes, if you are in one of the bigger cities and dealing with a sophisticated court, you are on a relatively stable playing field for getting a sensible judgment at the end of the day. It doesn't always work like that, but generally speaking, I think it's a fair approach. The problem is you may get an award from a court, but that does not mean that the defendant is going to take notice of it. They may stop selling, but what they may do is pass, if they're a manufacturer, for example, they may pass their molds to someone else, and it effectively becomes something like a Phoenix company that just effectively disappears, and another one starts up one step behind it. And certainly in terms of damages, it's very difficult to enforce damages award. Now, again, there are moves to try to improve enforceability of judgments in China, but in our experience, there's still plenty of room for improvement, and it is something you need to be aware of if you're going to take action in China.
All right, thanks. I'm conscious of time. Tom, any sort of closing words that you'd like to say before we wrap up?
Yes, thank you, David. So two things. One is to, again, say that if you feel that the CBBC Alibaba MOU can be of help to you, please do get in touch on that. And secondly, it is to maybe repeat something that both Jamie and I have said a number of times, actually, which is that there are quite a few new initiatives being brought out by the platforms themselves, particularly Alibaba, but also by the Chinese government, which will take a bit of time to bed down and show some results. But this really is an area where people are trying a number of new initiatives to try and make things better. So hopefully in the coming weeks and months, we can see some of these knotty problems that the people are reporting through their questions today. Hopefully we will see some resolution or improvements in these areas.
Thanks, Tom. So I think we'll conclude. Thank you to Tom and thank you to Jamie for your time, your expertise, your knowledge today. Before we go, I wanted to draw your attention to a couple more webinars. There's a few in this area that we have coming up on the 29th of July, the 19th of August, and the 27th of August. So these are sort of vaguely, or some are directly connected to IP and others close enough to the area. Hopefully those links will be clickable for you if you want to go and register for those. We haven't quite put the information for the 19th of August up at this point, but it will go up on our website. And finally, on the 15th of July, there's another one on a slightly unrelated topic, but it might be just another part of your business or something that's useful for you to know. 10 things you need to know about exporting to China. So I think that's pretty much it for today. As I said, thank you very much to all our listeners, and thanks to Tom and to Jamie for your time. So I wish you all the best, happy, successful business in China. If you have any questions, please do get in touch with me. You should find my contacts on all the emails that you received about this webinar today. If you have any webinars that you'd like us to hold in the future, please get in contact and suggest topics, and we'd be happy to facilitate. So I think that's about it. Thanks very much, everybody, and we'll see you all next time. Bye now.